Hi, I'm Shaye Larkin and thank you for visiting. If you've watched my other videos, you know that I'm a bankruptcy attorney here in San Francisco. And in this video, I'm going to talk to you about exemptions. I touched on exemptions in my longer video about the differences between Chapter 7 and Chapter 13 bankruptcy, but I didn't go over the entire rule about which exemptions to choose, and I didn't go into detail. I want to do that in this video where I have more time. Now, exemptions are what we use to protect assets in bankruptcy. And while they're important in many types of bankruptcy, like Chapter 13 and Chapter 12, they're most important probably in Chapter 7 because non-exempt assets can be liquidated for the benefit of creditors. And we choose the set of exemptions based on where we've lived. We start looking at the 2-year period that directly arose before the day that we filed bankruptcy, and we ask if my client has lived in California for the last 2 years. If they've not lived in California, if you've not lived in your current state for 2 years, then we look at the 6-month period that arose directly before that 2-year period, and where you lived for the majority of that 6-month period. So for at least 91 days during the 6-month period before the 2-year period. I don't know why they had to make it so complicated. They changed the exemption rules in 2005 when they overhauled the bankruptcy code, and they made it more technical. So that's the rule. We start with the 2-year period. If you've not lived in your current state for 2 years, then where did you live for the majority of the 6 months prior to that? Now, let me give you an example of a potential client. This person has only lived in California for 6 months. So I ask him, where did he live for the 6-month period prior to the last 2 years? And he says Kentucky. So at first glance I might think, oh, bummer that we can't use California exemptions because those are so generous. But then I look at the Kentucky exemptions, and it allows us to use federal exemptions, which are even better than California's, because my client happens to be married, and federal exemptions can be doubled if you're married. So yay. We choose those exemptions, and fortunately for my client, everything that he has is exempt. Now, if my client had lived in California, where I'm located for 2 years, for the past 2 years, then we would have 2 sets of exemptions to choose from. We could choose either the set with the generous homestead exemption or the set with the generous wildcard exemption, but we can't mix and match. And if my client has a house with a lot of equity, then I would choose the set with the generous homestead exemption. Say he does not, so I choose the wild card set instead. Now, that set of exemptions does have a homestead exemption, but it's kind of small, but you can combine the unused portion of that homestead exemption with the wild card exemption and get a total exemption amount of $30,825. That would be what I could protect with those 2 combined. And that's currently, as of today, March 26, 2020. Exemption amounts change over time, so you always want to make sure you get the latest numbers for sure. Now, that's not the only exemption in that set of exemptions. Both sets have exemptions for cars, exemptions for household goods and furnishings, exemptions for retirement accounts, exemptions for jewelry, tools of the trade. There's a long list of exemptions, and the key really is to visit an attorney, because bankruptcy attorneys, we're very familiar with exemption systems, and we can make sure that we're using all the appropriate exemptions for your assets. Well, what happens if you have an asset that either is not exempt or exceeds in value the amount of the appropriate exemption? Well, you have some options. One option is to not file bankruptcy if that asset is going to be at risk and you really had your heart set on Chapter 7. But maybe that's not an option for you. Maybe bankruptcy is really where you need to be. You could look into Chapter 13. I discussed this in my video about the differences between Chapter 7 and Chapter 13. In Chapter 13, assuming you meet the eligibility criteria to file that type of bankruptcy, you can protect a non-exempt asset simply by paying into the plan the amount that your creditors would have received in a Chapter 7 had the asset been liquidated. We call that the liquidation test. Chapter 13, the plan must meet the liquidation test in order for it to be approved by the court. So that's another option. There's a third option, and that is you can negotiate with the Chapter 7 trustee. The trustee is the person who's appointed to administer the bankruptcy, and they are the ones in charge of liquidating non-exempt assets. They don't necessarily liquidate every non-exempt asset. They have to decide what's worth their time and what isn't. Is liquidating this non-exempt asset likely to result in a significant amount of money to go to creditors? And trustees actually get fees when they liquidate an asset, so it's kind of a for-profit thing. But they have to act on the best interest of the creditors, and they look at whether this is something that's going to be profitable or not. And if they decide, yeah, we're going to move forward, then you can negotiate with the trustee and offer a sum of money in exchange for them not liquidating the asset. And you can even ask, can I pay this over time instead of one lump sum? Now, I can't stress enough that it's really important to talk to a bankruptcy attorney, because these things are technical, they're complicated, and you may be a rocket scientist, you may be brilliant, but if you've not practiced bankruptcy law, these rules can be confusing. And even for other attorneys that are not bankruptcy attorneys, they need to consult with bankruptcy attorneys, because we know this stuff. So I'm going to leave it off here, and then check out my other videos. I'll be making videos over the next few months about all aspects of filing bankruptcy, and I hope you enjoy them. Bye.